News and information, 570 AM, 96.3 FM, HD2, KLIF.
The Supreme Court heard arguments today about the campaign finance law. Joining us now is attorney Chris Gober with Gober Hilgers. Chris, thanks for joining us. A case, McCutcheon versus the Federal Election Commission. Tell us about what this case is challenging.
Well, federal election law limits the contributions that an individual can make in two ways. First, there's the individuals are limited in how much they can give to each candidate and political committee. For example, an individual is currently limited contributing $2,600 per election to a federal candidate. This is the more commonly recognized limit, which is known as the base limit, and it's not being challenged. What is being challenged is a second type of limit, which is the lesser-known aggregate limit that caps the total amount of contributions an individual can make to candidates and political committees during a two-year election cycle. So, for example, an individual under the current law is limited to contributing $48,600 to all federal candidates combined during a two-year period, and that's the limit that's being challenged in McCutcheon.
So McCutcheon, I guess, is the guy that would, I assume, wanted to spend more, and this has gone all the way up to the Supreme Court?
Absolutely. A three-judge district court upheld the limits. McCutcheon and the Republican National Committee, who were the plaintiffs in the case, appealed, and the Supreme Court agreed to hear the case.
Now, I think I know why this is significant, but since you're the expert, why is this important, this limit?
Well, these contribution limits, and if they do get struck down, they won't have a significant impact on the vast majority of contributors. You know, most of us aren't making $100,000+ in political contributions every election cycle, but there are a limited amount of donors out there that have the financial means to contribute to a greater number of candidates and political committees that are falling subject to this cap. So what this lifting this limits, what that would effectively do is give these donors the ability to make contributions to more candidates. They would still have to comply with those individual contribution limits to each one, but they wouldn't be limited into the number of candidates and races that they could engage in.
We're talking to Chris Gober. Okay, I guess because it's 2013 and we're all a little bit jaded, but obviously there's a reason that these caps are here, because we don't want people to have too much political influence, I guess would be the best way to say it.
Right, and that goes back to the seminal Supreme Court case on this, Buckley v. Vallejo, which was back in 1976. And, you know, the court has upheld contribution limits because they are seen as a constitutional means to prevent quid pro quo corruption. So campaign contributions in exchange for political favors. But when you start getting into the limits on a contributor's or a donor's ability to give to, you know, a certain number of candidates, I think there is a question as whether that is a necessary means to prevent quid pro quo corruption, because they're still subject to the limits to that candidate or committee, which, you know, reduces that chance of quid pro quo corruption. So I think a lot of people view this overall limit as overreaching in order to, you know, prevent the harm that these limits are supposed to protect against.
Well, a lot of people have their eyeballs kind of glued to what is going to happen today. Why is this significant?
Well, I think that, you know, as I mentioned earlier, I think that the case may have limited impact on the vast majority of contributors. But I think a lot of people, including me, who were really watching this case, one thing we were interested in is seeing whether the court and the 5 justices who have recently been voting to invalidate campaign finance restrictions would use this case to really revisit Buckley and contribution limits altogether. And whether I think what remains to be seen is the case and the holding going to be limited to the aggregate limits that are the subject to the case, or is there going to be some type of broader rollback on contribution limits altogether?
it looks like at least a revisit, quote, is probably needed. How do you think the Supreme Court will see this?
Well, I think that if today's argument was any indication, in most of these campaign finance cases, the court really kind of takes a 30,000-foot view approach on the constitutional issues. And the difference in today's argument is they really were asking about the nuts and bolts of the campaign finance system and how money exchanged hands and how campaigns raised the money and it moved the money. So they were really getting into specifics, I think, in order to try to get a better understanding of how it all works in practice rather than just theory. I think to make a more educated ruling on what limits are needed to prevent quid pro quo corruption and which ones are superfluous.
Interesting. What does your gut tell you?
Well, I think that there's 3 judges on the court that would, I think, overrule Buckley altogether. I don't know that they'll get 5. I think that you could certainly see a rollback and the aggregate limit struck down. I think it's hard to read the tea leaves from today's argument because there didn't seem to be one position that 5 justices seem to get behind. And so I think this is going to be one of those outcomes where there will probably be a bargain for middle ground that comes out of this one, if I had to take a guess.
Chris, thanks for joining us. If people have legal questions for you, I know you've got a website.
Our website is www.goberhildgers.com.
Chris, I appreciate you jumping it on. Thanks.
All right. Appreciate it. Thank you.
That's attorney Chris Gober.